So, hello everyone, I hope you can hear me. My name's Richard Harrison, Director of Innovator International, and this is our first ever Tuesday morning coffee club, covering intellectual property for international innovators. This is the first session. This is us using a new platform. The only thing I can guarantee is everything won't go swimmingly perfectly. I hope it does, but I'm sure we'll have a few glitches, so please bear with us. This is a new weekly session we're looking to run covering the typical topics that are requested by people on the Innovator Founder Visa, Innovator Startup Visa and other routes. And one of the questions we're most commonly asked is about what used to be called the intellectual property condition for settlement. But it's changed. Lots of things have changed, only subtly. But it's now more about research and development than it is about intellectual property. So let's dive straight into the session. We have got a great guest today, Chris Aldridge, who I'm going to introduce in a few minutes' time. But let's start by looking at specifically what the Home Office requirement for IP actually is. So I'm hoping you can see that on our screen, okay? Good morning to everyone coming in the room. Just by the way, if you're not watching this live, we've got it as a recorded session. We'll have every session recorded on our YouTube channel. So please do watch these sessions, do engage, but come back to us with questions and any other topics that you want us to cover. So the Home Office settlement targets. These have changed subtly, but only really in title, not in content. And people used to refer to this as the intellectual property target. Now it's actually called the research and development target. But it's still the same thing. So let's go through the specific wording. The business has engaged in significant research and development activity and has applied for intellectual property protection in the UK. Now we've got two massive things there. You've engaged in significant R&D activity and you've applied for intellectual property protection in the UK. Two quite different things. Now, the Home Office now give us some sub-notes. There's actually a lot more notes in the guidance for endorsing bodies. But the sub-notes here say, when considering this option, it's important that both parts of this provision are met, i.e. significant research has gone into the intellectual property protection application. For this reason, you should not consider IP types that have not demonstrated the significant R&D component. And we're going to go into that with Chris in a few more minutes, but there we go. There's the headline. This is what it's about: intellectual property, research and development. If we have confusion over the definition of research and development, we'll do a session on that in a couple of weeks' time. But hopefully we'll be able to answer all of your questions on this this morning. Now, the big thing here now, why does this target exist? Well, the IP comes in two massive areas. Firstly, at the point of application, and secondly, at the point of settlement. Because what the Home Office really want to see is you, the applicant, the business owner, developing your own intellectual property. And one thing we've not done yet is tell you or define what intellectual property is. So let's take a step back. Intellectual property, two simple short words. Intellectual property, intellectual, of the mind, thoughts, property, something you own. So intellectual property are the thoughts that you create and the thoughts that you own. And typically within a project, the Home Office want to see you creating and developing your own, or the majority of the intellectual property within your project. They don't want you to have a concept, a high level idea that you then outsource the clever parts, to someone else. They want you primarily developing, let's call it the guts of the idea. We're going off on a little bit of a tangent now. We can cover the R&D separately if we want. But this is where we're talking primarily about the development and the protection of intellectual property. So with no further ado, what I'd love to do is bring in today's guest. So first tech check. Let's see if this button works. Chris, can you hear me okay?
Hello, I can hear you.
Fantastic. So hopefully you guys can all see Chris on the screen and you can all hear Chris. Chris, start off quite simply by telling us who you are, who you work for. Well, let's start there. Who are you and who do you work for?
Yeah. So I'm Chris Aldridge. I am a patent and trademark expert. I have worked in intellectual property and protecting intellectual property rights for over 20 years. and I currently work for my own business. It's Mohan Aldridge Sykes, which is based in Leeds, but we have clients all over the UK and abroad.
Fantastic, thanks, Chris. And just for everyone's knowledge, I am going to be sharing this at the end with Chris's personal details, the website. So please listen away for now. We will get that back up at the end and get Chris's details out to you. So, Chris, on a day-to-day basis, you mentioned you're a patent or patent. Is there a correct way to say it?
There is no difference. It's just however you're comfortable.
Fantastic, thanks. Okay, so we patents, but they're not the only forms of IP that you cover.
That's correct. Yeah. So, in terms of IP protection and what we can apply for, there are three main rights. There's patents or patents, trademarks, and designs, and each one protects a different aspect.
Fantastic. Okay, so we can go into that in a bit more detail as well. But I mean, there are other forms of IP that we can't cover as well here. I mean, copyright is something that's spoken about quite regularly. But am I correct in saying you don't actually apply for copyright? It's just granted?
That's correct. In this country, when you produce a work, an artistic work, or another piece of work, there is copyright already in the project. But what you do need to do is make sure that it's clearly dated.
Okay, fantastic, thanks. But I mean, most importantly here, I mean, I'm saying most importantly, we're going to change the priorities of this as we move around a little bit. If I go back to the Home Office requirement, which, Chris, you can't see, it's actually on the screen now, we talk about applied for intellectual property protection, which is why, precisely why Chris there has explained that the three types that we can apply for are patents, design rights, and trademarks. Now, trademarks is a bit of an interesting one. I'm going to go into that one last. But Chris, let's start with design rights. Can you tell us a little bit about design rights, what they cover,
Sure.
and the process for protecting them?
Of course, yeah. So design rights or registered designs, they're in the US, they're called design patents, and they're slightly different there. But in the UK, it protects the aesthetics and the contours and the way that something looks. So a way that a product looks, or it could be a logo. And it's usually a three-dimensional object. So you could protect a mug or a hairbrush or something like that that has an aesthetic appearance. Now, the designs do need to be new, although there is a 12-month grace period. So if a design has been put into the public, it's been launched on a website, there's a 12-month window to get UK registrations in place. They're very quick. They're generally registered within a week or 2 weeks, and they're relatively cheap. I say relatively because when you compare it to other rights, it is relatively cheap.
Okay, but so really design rights. We're looking at design rights if you're looking to protect the design around an object.
Yeah,
look and
absolutely.
feel.
If you've got packaging or a product that has a unique look, in theory, we can protect icons on computer programs or layouts of screens.
Okay.
So there's various things we can protect, and it's initially registered for 5 years and can be renewed up to 25 years in 5-year blocks.
Okay, so I suppose the clues in the title there, design rights. We are purely protecting the physical or aesthetic design of something. Okay, fantastic. I'm going to go to trademarks last. No. Let's do trademarks now. Trademarks is a really interesting one, and going back to the Home Office definition. What's most important here is the R&D behind it. And I always use this example. This logo in the top right corner of the screen, Innovator International. If we have trademarked that, of course, but trademarking that would not let us meet the criteria for this condition for settlement because there hasn't been any research and development behind the design of that logo. But you may have something you've designed or developed, you can't or don't want to get your design rights or your patent, but you want to keep it as a trade secret. You want to keep it as a trade secret, but equally you've earned the right for this settlement criteria. In that case, you may go for a trademark, but that trademark has to be synonymous with or closely connected to the R&D. So, for example, we've developed a tool for assessing the maturity of emerging propositions, business propositions. We put a lot of work into the development of that tool. We called it a maturity matrix. If we trademarked maturity matrix, we'd meet the criteria for the Home Office. But trademarking Innovator International would not meet the criteria because it's the maturity matrix that's connected to the R&D we did. Sorry, that's more, Chris, for the people watching. Clearly, you know that anyway. So, Chris, trademarks, what are they? What do they cover? How do you protect them?
Sure. So everyone will be familiar with trademarks. You see trademarks every day. All the big brands have protected their name. And it's protection that will last for initial 10 years, and it's renewed in 10-year blocks indefinitely. So there are some trademarks that have been on the register for over 100 years. And it's all about protecting your brand, and your name, your headline name. And as part of the process, you need to nominate what goods and services you're going to use that name on. It's best to protect a word mark because that will protect stylization of that name. But if you've got a distinctive logo, that might be worth protecting on its own. If you think of, for example, Wall's ice cream in the UK, overseas it's not known as Wall's, but it has the heart motif in every country, just to tie the brand together. You need to decide what you're going to use the name on, and we list those in the application.
Well, this is what we're going to go into in a little bit more detail in a few moments. So, for example, for those interested, the Innovator International logo in the top corner, the name Innovator International is protected, written in that way, but also that little circle that you see around Innovator International and also used as the O on Coffee Club. We've trademarked those as our logos, our tokens. So yes, it's good to trade. Well, it's essential to trademark your business, but trademarking your business name wouldn't necessarily allow you to meet the criteria for this specific visa condition. This is quite precisely around protecting something that has R&D behind it or research and development behind it. So, Chris, on to the big one. Now, normally, before we go into this one, if you're getting a trademark, trademarks are quite simple, quite straightforward. If you're comfortable, it's something that's quite easy to do yourself. We did ours on our own. We've got a reasonable knowledge in this area, but I would never touch a patent on my own. Never, ever, ever.
Good.
Because we've seen so many people who have patented something and the patent's absolutely useless because they've not protected it in the right way, they've not termed it or structured it in the right way. So patents, quite clearly the most complex of all, Chris, and the most expensive of all.
Yes.
Tell us a little bit about patents, what they are, what they do, what they protect, please.
Sure. So patents protect a product or a process. So the way that something works or the steps that you're taking to make a system or a method or process work. They have to be applied for before the invention is put into the public domain. And this is absolutely critical. A lot of people will put their invention on the website and then look for patent protection, but it's far too late at that point because an invention needs to be novel, which means it's not in the public domain before the date of filing. And the other main criteria is that it needs to be inventive. And this is very difficult to assess. It's a question of whether something is obvious over what's already out there. It's incredibly subjective, and sometimes the worst people to assess that are the ones that have worked on the project because things always seem obvious to them.
Yeah.
From a legal point of view, it's not usually as obvious as the person seems to think.
So would I be right in saying, I'm going to use this example here. We've had this amazing project. This person's actually settled in the UK now. I hope they don't mind them using their project. I won't name it for privacy reasons. Let's say, for example, you are creating a flavoured drink. You couldn't patent a flavour.
Well, yeah, possibly. It depends on the chemical components. So if the components or the range of ingredients is novel, then it might tick that box. Is it inventive, or are you just tinkering with sugar content or fruit syrups? That's going to be the question there. But okay. You can get patents granted for so many different things. Obviously, chemical compositions.
How's software now, Chris? Because software was a problem a decade ago.
Yeah.
Can we patent software?
So yes and no.
Talk to an expert is the answer.
Absolutely so, yeah.
Okay, so
Patents Act is from the 70s, and back then software was very different. We'd just come out punch cards. So there's a line in there that says you can't protect computer software as such. Copyright would protect the code in the computer software, and it's worth putting dummy code inside your software code just to show someone has copied it.
Yep.
But what we'd actually be looking to protect normally is the method of what we're doing, almost like a flowchart.
Fantastic.
The step that we're taking in the software.
Fantastic.
There's very little value in protecting an algorithm.
Yeah.
Because they can be changed or circumvented. So it's the steps in our process that we're looking to protect.
Got it.
So software can be done. And then simple things, garment hangers, hairbrushes, all the way through to complex materials.
Fantastic. Chris, I'm going to pop into some questions in a minute. We're getting some questions in the box. But I mean, by way of example, this fantastic team who produced this drink, they wanted to keep the way they brewed the drink private, so they actually trademarked the name. But that name is synonymous with non-alcoholic drinks brewed in a traditional way. So it was a great result for them. But Chris, actually, before I go on to the next question, cost-wise,
yes.
Trade. So if someone was to come to someone like you and ask for help with a trademark, we're looking at a fee of typically. I mean, real wet finger in the air here. Just the reason I'm asking this question, Chris, is
£1,000 probably.
Okay.
But the cost will depend on the number of
the number
is listing. So it's variable.
So,
but if you budgeted £1,000, you'd certainly have enough there.
Fantastic. And how does that compare to design rights?
Design rights probably less than 500.
Wow.
With designs, there's value in having more than one design.
Yeah.
So if you have versions of a product, the more designs you have in the single application,
the better coverage you've got.
Design. So
I'm with you. Well, Chris, I want to go on to this in a couple of minutes as well. Before I go on to this now then, but patents. And I know the answer to this is how long's a piece of string. But when we're talking about patent applications, you were talking about costs starting from,
for a very simple mechanical invention, maybe £4,000 for the drafting and filing process. More complex things in software and biotech, maybe up to 5, 6, 7,000. It all depends on the complexity of the invention.
And countries you want covered, I guess, it differs quite substantially.
For the UK, those figures would be about right, and there are ongoing costs. So over the next 2 to 3 years, probably another 1, 2, 3,000.
Yeah.
Overseas protection, you'd file overseas at the end of the first 12-month period. So you have 1 year to then file overseas, and there are other systems that help with the cost of that, like the PCT or international patent that gives another 18 months before you then have to nominate the specific territories.
Okay. I mean, the answers to these are showing me that, especially patenting, is such a complex area. That's where you need help. But this is where, for me, it's important to pick the right portfolio of tools that you want, or right portfolio of patents, because typically a lot of the people listening now, and again, for people throwing in questions, thank you very much. I will get onto these. The majority of the people listening at the moment are thinking about intellectual property to meet a certain aim, to meet a certain goal. And that goal is settlement target number 3 for the Home Office. So it's about ticking a box to say, I've done this, I've done something else, I've met the criteria for settlement. But we should be thinking about IP in terms of so much more than ticking a box for the visa conditions.
Absolutely.
I mean, why is IP so much more important than that, Chris?
Well, if you've gone to the effort of doing the R&D, there's no point in just giving that away. There's so much value in having your IP protected. It's an asset. It can be bought and sold. It can be licensed, just like any other property. Although it's intangible, you can't physically touch it. It does have value. So a patent can be worth thousands, tens of thousands, potentially millions, depending on what it is. A trademark will also attract goodwill and have brand value. An example I often use is Cadbury's, that's sold to Kraft. a few years back for several billion. And of course, they had a factory, they had people, they had machinery, all of which could have been replaced. But what others didn't have and what they wanted was the brand, the goodwill. So the protected names, the trademarks. So there's a lot of value in this. If it's a tick box exercise, you can tick the box and you can give away all of your efforts and just let the market swamp you over. But if you want to protect your position and make money, have the ability to stop people from copying you, you need to get the assets in place.
Yeah, absolutely. I mean, that's the big one as well, to stop people from copying you, especially if you want to build and scale your business. If you've protected what it is that you do, and there's some pretty big players chasing you, you've got one or two choices. You can they either can't infringe on your territory, or alternatively, you've got all of the tools, you're holding all the cards to make a deal with them and either sell them the IP or license them the IP. So effectively, IP gives you another string to your bow in terms of what it is you do or what it is that you sell.
Definitely. And I think you've hit the nail on the head. It's the tools to be able to make stuff happen. If you don't have the tools, you can't do anything. You sit back and you let people take your market share. If you've got the tools, then you can threaten them, you can take action against them. It's like having insurance. You don't want to use it, but if you've got it there, it's that safety net.
Yeah. No, I mean, I'd heard sometimes. So again, to everyone listening to this, please don't think about IP purely as a settlement target. I know that's the thing that's most important to a lot of you, but if you build your business, if you build this scalable, this viable, scalable business, then the other targets will fall out. I mean, it may be a choice. It may be that you get some IP, you sell that IP, and you can hit your 500k target or your £1 million target, or you need to employ more people. So, making the business work is the most important thing of all, and IP is fundamental. I mean, we didn't realise how the Innovator International brand would grow to a point where it's recognised internationally for what we do, and now that brand is so valuable to us. So protecting it was the most important thing. Chris, I've waffled away for so long there, I've totally forgotten what question I was going to ask you next. Someone once said a while ago to me that IP is only as valuable, I'm about to repeat this, IP is only as valuable as your financial means to protect it. So I think the point there was, if you have to defend your IP, it might be very, very expensive. But that said, I was more of the opinion that having IP protection was a deterrent to others.
Well, massively so. Absolutely. If you've got it, then you can use it as a deterrent. Enforcing it is often expensive. You can get intellectual property insurance that will help protect against people infringing or attacking your IP. But having it is key, and you can find people that will fund litigation if it's a strong case. People will invest in IP. Another option is that the infringer buys your company or buys your IP. So there's exits involved in having IP.
Yeah. And the bottom line is, you're on the right side of the law by having the IP. They're on the wrong side of the law by infringing it.
Absolutely. So, and with social media these days, these cases, I mean, you'll have seen on the news bully boy tactics by some big brands attacking smaller companies that are using similar names, but for very different goods and services.
Yeah. Chris, I've heard this. I don't know if you know this offhand. iPhone.
Yes.
How many patents?
Oh, so many.
Is it hundreds?
Probably thousands.
Thousands. Yeah.
Absolutely. So all the big phone companies are fighting each other constantly over patents and essential patents and everything else that's going on.
And I guess you've got design rights around the camera and around the shaping and around the whole thing. And Chris, it's nearly 25 past. We've got 5 minutes to go. We've got a few questions coming in. I'd love to work through these quickly. So the first one is, when we were talking about design rights, a question came in. Is that protection on platform design applicable in the USA, EU as well, or do we have to apply separately to get these? Now, I think this is probably a fairly broad brush question across trademarks, design rights, and patents. What's the UK versus rest of the world situation?
So generally on a worldwide scale, it is country by country. So we need US patent or trademark to protect the US. There are EU systems, so you can get an EU trademark that will cover all 27 member states, similarly with designs. And last year, just over 12 months ago, a unitary patent was set up, which covers 17 member states of the EU. So there are some territorial systems, but generally it's a country by country basis.
Okay, so if someone wanted to protect their design in Australia or stop someone in Australia copying it or America copying it, would they then have to look at the respective systems within each of those countries?
Yes, so we have relationships with attorneys all around the world that can file applications for us, they can enforce them for us. So our clients will speak to us first, and we'll contact our associates in whichever country it's needed, and they'll help us out, come up with a plan, and see what we can do.
Fantastic. Well, that answers my next question. Who do they speak to? So yeah, no, that answers. Let's go on to the next question. Can we get IPP? I'm not sure what IPP. Are we talking about patent protection, possibly?
IP protection?
Sorry, intellectual property protection. So can we protect the concept of a marketplace? So I think we're talking about an online marketplace here.
Because it has to be different from Amazon or eBay. So the patent protection is unlikely, but there'll be a brand name associated with it, depending on what R&D has been done for that.
That's the big thing there, the R&D. Yeah, absolutely. So our R&D here, I'm just going to butt in, sorry Chris, R&D here, we're not talking about, if we're talking, I'm going to do a separate session on R&D, definitely, but primarily, if the R&D, you have to be creating something that's scientifically or technically different from what already exists. So the concept of a marketplace, if you go to a coder and say, could you create me a marketplace, and they go, yeah, no problem, here you go, this is what you want, then you've not really done scientific or technical R&D there. So I don't think you'd be able to protect the concept of a marketplace from the R&D point of view, unless there's something significantly or technically different. But Chris, if your marketplace had a unique look and feel online, could you get design rights over the interface or the look and feel?
Yeah, potentially on the interface, you could get design rights in place, you could get the registered trademark.
Yeah.
So there are things that can be done, but patent protection is unlikely.
Yeah, and again, I'll back that up by saying the R&D is unlikely as well, unless there is genuine. I mean, the one thing I didn't say, and I'll go into this in the other session, is if you think back to British schools, and I assume they're the same globally, in science, if you had a problem, you'd write a small bit of text. What's the problem? How did I solve it? What happened? What went right? What went wrong? What was the outcome? But you get involved in an experiment, an experimental process. And that's really what we're looking at, some sort of scientific or technical experimentation to reveal something that wasn't otherwise known. I'm going to fire into the last question. We've got a couple of minutes left. Talking about the software tweaks, patenting software.
Yep.
The working mechanics of a software, algorithms, and data analytics, can they be protected?
It's generally not advisable to protect algorithms because they change, and within 2-3 years, usually before a patent is granted, they're likely to be outdated. So it would be the method. What are we doing? What are the steps here? Taking data, processing it, putting something out at the end. And it needs to do more than just run through software on a machine. It has to have some interaction with the outside world as a general rule. And I think on the R&D thing, if you're overcoming a problem, then it's likely there could be something patentable there. It's a similar test.
Bottom line for that one, speak to Chris. We've got one more question. This is the last question I'm going to answer at 10:29. We're coming to an end. Thank you for everyone's patience. Can you protect a course that's quite different from what's existing? I'm going to ask us both to answer this one separately. I'd say the R&D on a course is very, very difficult because normally what happens with a course is you're repeating information that's already known. So the R&D, you might have researched something about the course, but you've probably not made a scientific or technical breakthrough. Now, if you have made a scientific or technical breakthrough, then potentially there's something there. So again, I'd say the R&D behind a course is questionable. And the Home Office actually use that as an example on their website. They say you're repeating knowledge that already exists. You're not creating new knowledge. But Chris, from an IP point of view, how do you protect a course?
I think very similar. we'd be looking at trademarks, we'd be looking at designs. We could consider a patent if there is a new method of teaching or a new way of doing something. But if it is repeating what's already out there, it's not going to be considered new, so it wouldn't be patentable.
Chris, thank you very, very much. We've run out of time. Thank you, everyone, for the questions. Thank you for watching. Thank you if you're watching this back on YouTube as well. Before I go, the most important thing we've learned from this is please, please, please connect and speak to Chris. On the screen, you'll see Chris's LinkedIn page, Chris Aldridge. On the right, you'll see Chris's website, Moan Aldridge Sykes. I've not put the web name there, but if you Google it, you'll find it. Or equally, there's a link to the website from Chris's LinkedIn page. So again, thank you very, very much for your time. Thank you for listening. I'm hoping we've got an amazing guest next week talking about internationalization and how to do business in different international cultures. I'll tell you more about that in the next week. But I'm looking forward to hopefully seeing you all next Tuesday. So thank you very, very much for tuning into our first ever show of the Tuesday Morning Coffee Club. Hopefully we can make this a screaming success over the next few months.